Well, let's stay with this story. The Democratic Alliance, which is a major partner in the government of national unity, has thrown its weight behind President Cyril Ramaphosa's bid to mend relations with the United States. Pretoria is set to send envoys to Washington to explain the contentious land expropriation law, which has led to U.S. President Donald Trump halting aid to the country. Let's understand now the court challenge of the Democratic Alliance. Its spokesperson is Karabo Khakhau, and she joins us via the virtual platform. Ms. Khakhau, good evening to you, and thank you very much for your time. If you were to explain this to an ordinary person on the street, what would you say is wrong with the Expropriation Act in its current form?
Good evening, Oli. Good evening to South Africans. Thank you very much, firstly, for having me here. The point of contention here is simple. The apartheid government in the past was able to, with sweeping powers, be able to take whatever land they thought was within their right to take from whoever and use it for whatever purpose they want. And it is on the basis of that that we find ourselves here as South Africans today, having to address the land question, having to deal with expropriation, having to deal with redress and land reform. And it is on the basis of that responsibility that, or the abuse that the apartheid government had taken, had used in the past, that we do not want to have a democratic dispensation also responsible for that grave miscalculation of how democracies are supposed to work, one, and two, having a trampling on the South African Constitution. The Democratic Alliance has always been firm to say Section 25 of the Constitution achieves two things. One, on the one hand, it protects property rights. On the other hand, what it does is to give a clear agenda of how to deal with redress, land reform, and a restitution in expropriation in the country. So it is very important to make sure that compensation is something that the government is still able to achieve for public good. What we also do not want is to have a South African constitution being used as a political manipulation tool for politicians. When you and I read an act, Koli, we can't read the act with confusion on what the truth is. We can't have it as an open-ended act where if it's Karabo in administration, then I can expropriate this way. And if it's you in government, then you can expropriate another way.
Yeah.
We must be able, irrespective of administrations, to read the act accordingly. But we also are of the fundamental opposition of here, beyond the constitutional weight of our challenge here, is the procedural flaw that we have explained in the past, that we have witnessed as far as the NCOP's participation in passing the act is concerned. We know that of the 7 provinces that voted in favor of this act, 4 of them did not meet the master of negotiating mandates there. The Limpopo, the Eastern Cape, and Gauteng did not hold their provincial legislation meetings to get concurrence to go into the NCOP.
Yeah.
And the least we can do as South Africans, as South African politicians, is to, if we're going to expect the South African Republic to respect the laws that we are making binding to them, we at least need to, at bare minimum, make sure that the procedure we follow in Parliament is correct, and 2, that the acts that we pass meet constitutional master. We do not believe that the current Expropriation Act meets those 2 masters.
So I wanted to keep this conversation quite simple, which is why I started it the way that I did. But nonetheless, you've explained a mouthful. So again, I'm going to try and hone in what you seem to have a problem with, and I'm going to explain it this way. The Expropriation Act provides for fair compensation. The only exception, and that's where nil compensation is provided for, is when there is, again, the question around whether or not that land is being properly used or not. There are very clear guidelines as to when nil compensation will apply. Where is the confusion?
The confusion here, Koli, and thank you for that preamble. The confusion here is the open-endedness of the cases of nil. if I do not believe a particular property, if I am at the helm of the expropriation, if I do not believe that that property is being used for public good, then I can arbitrarily, with sweeping powers, be able to take it away without compensation. That shouldn't be something that any government has the power to do, because then you can easily abuse it in accordance to my liking, in accordance to any agenda that threatens property rights altogether. What you must be able to do is to still be able to afford property owners compensation in line with market value so that we can move all together. And what must also
Can I stop you for a moment? Okay.
Yeah?
It is not true what you have just said, that this law applies for land to simply be taken arbitrarily. That's why the courts are there. Again, is this not the risk that the Democratic Alliance runs, and that is that of misinformation, which are the repercussions we're already dealing with the new United States government?
Well, I think you are the one that is not understanding the act here. So it is true that you can be able to do so, because even with the process of the acts in place, there is the process to be followed, which is the second argument that we have as far as the substantive matter of the act is concerned. The process there to be followed is also there are two clauses that give two different marching orders to roll it out. Without clarity there must be one clause, one marching order, and no confusion on what to do. But the second thing that we have here is the responsibility again that is taken, that the act gives or puts on the shoulders of individuals who are seeking dispute, to seek the counsel of the court, irrespective of on which side of the negotiating table they sit as far as expropriation is concerned. The Democratic Alliance is of the firm view that that responsibility shouldn't be on the onus, shouldn't be on the shoulders of individuals, that the state must take absolute responsibility of that to make sure that there are fair processes of expropriation. But what I also want to clarify here, for South Africans to understand at the heart of what the Democratic Alliance is fighting for here, is striking a balance between two things in the same constitution, in the same chapter. Property rights protection, while dealing with the clear democratic mandate of land reform, expropriation, and redress. You cannot pit those two against each other, because they are protected by the same provisions of the same constitution. That balance needs to be heard altogether. Fundamentally, we shouldn't find ourselves in any position where any act or any law gives politicians sweeping powers to manipulate acts in favor of whatever political ideology exists for them. I'm going to give you an example. For now, the Minister of Public Works and Infrastructure is Dean McPherson, a Democratic Alliance minister. Tomorrow, that minister could be an EFF or MK minister, who tomorrow will, on the basis of the vagueness and the inconsistency of the act, can easily manipulate it to the outcomes that will not be aligned to what is a constitutional democracy as we believe it to be as the Democratic Alliance. And these are small things that we shouldn't even be having a conversation about. They're matters of clearing inconsistencies as far as procedure is concerned, so that we can stay true to Section 25 of our Constitution.
All right.
Something that the Democratic Alliance is committed to and has always believed has given the state sufficient power to use. And that's why we govern with an outright majority in the Western Cape. We have an 83% success rate of land reform cases in Cape Town, in the Western Cape lands. Why? Because we believe Section 25 of the Constitution is important. Okay. We believe in healing the injustices of the past. We equally believe in protecting property rights.
All right. So what you are now seeking to do is go about this, the legal route, which is probably what ought to be tested in the first place, the constitutionality of this new law. If the Constitutional Court comes back and says the law is certified as meeting the master of the Constitution, will the DA accept it? And now, instead of making it a problem, possibly go and explain it to places like the United States that this law does not provide for land grabs?
Look, the Democratic Alliance has always been a party of the rule of law, and so we abide with that. So if there is ever a position that is given by a court of law that seeks to maybe challenge or differ with what we were, then we will bite our humble pie and move in accordance if we've exhausted all avenues are possible to test this. But what must also be important here, because there's maybe an assumption that is created that the Democratic Alliance is to blame for part of how Trump's administration has sought to deal with South Africa. And that is not necessarily true. You and I would both agree that the signing of the Expropriation Act happened to be the final straw, perhaps as far as the South African relationship with the United States is concerned. There have been other trade negotiation terms that we were not able to find each other on, and that's part of why we do not have Starlink in the country and the rest of other things that could have been aligned in accordance to make sure that we honor trade partnerships, because when trade partnerships work, which I believe the USA, as we believe as the Democratic Alliance, that the USA forms an integral part of those partnerships. When those partnerships work, we're able to get to the ultimate goal, which is to grow our economy, attracting investments to balloon the economy enough to create jobs, which is what South Africans need to be able to put food on the table. And that's what we need to be able to move forward to. And we're glad that the Ramaphosa administration is engaged in the White House to clarify those things.
You mentioned Starlink. Does the Democratic Alliance believe that if Elon Musk is going to set up that particular platform here, there would need to be a local stake, a 30% stake that is owned locally for that company to be able to operate here?
So these are part of the negotiations that we're having in the GNU as far as BEE is concerned and the policies thereof governing trade partnerships are concerned. In all honesty, frankly, Xoli, we cannot lose out on a bandwidth connectivity that comes with unlocking job opportunities in South Africa, which is what majority of South Africans need in the country. And we lose out on that because we are inflexible in part of the legislation or the laws that govern how trade is supposed to happen in the country. And these are the things that we must be able to be honest about in South Africa, as far as what the ultimate goal here is. If the ultimate goal is to unlock economic opportunities that are in line with the fourth industrial revolution, which is technology-based, then we must be able to align ourselves accordingly. If the ultimate goal here is to make sure that each and every household has somebody that is employed who's able to put food on the table for themselves and their families, to be able to buy houses and afford a bond and buy a car and take their kids to whatever school that they want to, then equally, however we move with our international trade partners must then be aligned to that ultimate goal.
Yeah. The laws of a country ought to be respected, Ms. Khakhau, and I take it that you would agree with that, and which is why the United States is itself very determined to have TikTok owned locally there, because they are raising a whole range of issues. But the bottom line is that they've set up laws and they're saying if TikTok is to operate in America within 75 days, I think, is what that company has been given, it has to provide for how America can basically make it be locally owned. And so I'm just trying to give a flavor of why South Africa has got to stand on principle. But let's move on because we've got little time. The DA is part of the government of national unity, and the understanding is that you have given a commitment that you are going to be a party to explaining South African legislation in part to countries like the US. If you are indeed committed to that, how are you going to sell laws such as the Expropriation Act in order to correct the misunderstanding there?
Look, what is true is that, yes, we're part of government, but what's also true is that we are a party of constitutionalists, people who believe that any law must meet constitutional muster. We cannot, in all honesty, in all ethical reasons, be able to argue in favor of something that we have received legal opinion that it doesn't meet that which we stand for, which is the protection on and the respect of the South African Constitution. And which is why the first move, before coming to where we are right now, the first move was to write to the president ahead of time last year, when noticing that there are constitutional inconsistencies, asking that the bill be sent back to Parliament so that we can correct the inconsistencies that we have. Unfortunately, the president was not budging on that. Perhaps had he budged, we'd be having a different conversation right now. We wouldn't even have forces of some misinformation or some escalation of communication reaching international flows, risking altogether trade agreements such as the 3.6 billion rands worth of economic benefit that we get from AGOA and the 6 billion rands worth of funding we've received for HIV/AIDS prevention and treatment for South Africans living in vulnerable communities altogether.
Yeah.
Yes, we are government together, and because of that, because when we do not agree, that's why we've done two things. One, have invoked Section 19.3 of the Statement of Intent to make sure that there is sufficient consensus on any and all policy-related matters in the GNU, rolled out by the South African government, so that we don't have to be having such conversations outside of the negotiating GNU table. But two, beyond that, because we were unsuccessful in the first attempt to have to lobby the president in accordance with this, are now seeking the guidance of the court, which is the sole also, which is the ultimate also protector of the Constitution. And accordingly, we will march in accordance with the responses that we're getting there. Again, I want to just say here, the final submission here, particularly, is that we as the Democratic Alliance are 100% sure that you can still be able to achieve two objectives. The first being the protection of property rights, and still be able to achieve the objectives of being able to heal the injustices of the past, have successful cases of land reform, redress, and restitution. These two don't have to come at a compromise of each other. These things shouldn't be something that are up for grabs for whoever is holding political power for the day. These are things that should be guarded as per the act. Acts must be airtight enough to remove any sweeping powers of any political player for now and for the future.
Karabo Khakhau, the spokesperson for the Democratic Alliance, thank you very much for your time.